I've read that some people have said that, that there's already in place legislation that covers the conduct that has caused lots of problems last season. If I could deal with, firstly, offensive behaviour. Over the last few years, breach of the peace, common law crime of breach of the peace has been developing, really as a result of the European Convention of Human Rights, which requires a citizen to know what is criminal and what is not. And the argument is that breach of the peace is ill-defined, and the limits of the crime are really not defined enough for a citizen to know whether certain conduct would be criminal or not. For example, recently, and when I say recently, we're talking the last couple of years, breach of the peace has been held to apply. There has to be a public element to it. So, for example, any conduct in a private dwelling house is no longer a breach of the peace, and that was the case in the early 60s in various cases. Further, the definition of breach of the peace requires the conduct to be severe enough to cause alarm to ordinary people and threaten serious disturbance to the community. The conduct must be genuinely alarming and disturbing in its context to any reasonable person. Now, there have been cases where this definition of breach of the peace has resulted, and I don't want to name names, but I'm quoting from case reports, where a sheriff has ruled that supporters shouting racial abuse at a black player, another supporter grunting in an ape-like fashion, and again shouting racist abuse at a black player, that didn't amount to a breach of the peace because, quote, the view was taken that the conduct was over very quickly, that it was not flagrant, that it took place in the midst of the cauldron of sound which emanates from a large sports crowd, and that it could not be interpreted as conduct which would be alarming or seriously disturbing to any reasonable person in the particular circumstances of a football match. We have seen conduct at football matches where defences are run, that there is no fear and alarm caused by offensive chanting and singing, and that at the end of the match it was clear that there was no public disorder resulted. Now, what the Act seeks to do is define what the behaviour is, to set out a definition of offensive behaviour so that the police and the courts can apply it to the conduct itself. And breach of the peace, I should add, could still develop because it's a common law crime, and it could still develop as a result of further cases and further jurisprudence. Now, that deals with current law breach of the peace. If we move on to threatening communications, the problem with threatening communications is it's covered currently by the Communications Act of 2003. However, as a result of case law, particularly down south, the definition of sending, because that's what's criminalised, sending a communication, doubt has been expressed as to whether sending includes posting, blogging, or using or accessing Twitter. Now, what the Act, the second provision, seeks to do is it puts an end to any doubt in respect of that. And further, the Communications Act 2003 is prosecutable only summarily. Now, I have seen, and I don't want to get into circumstances, I don't think it would be appropriate in this forum, but I have seen some of the vilest postings on the internet glorifying in someone's murder, threatening to kill someone with details of what that would involve. Now, you may say, and it's a matter for the courts, that may be worth a prosecution on indictment. And if that's a view that a prosecutor takes, then currently we can't do that because the maxima is only prosecutable only summarily. So again, the Act seeks to put an end to or extend the penalty but again put an end to any doubt as to what the definition of sending means. Now, what I alluded to, the Joint Action Group this morning, as you would expect, guidance will be given by the Lord Advocate to Chief Constables as to what the offences are intended to cover. Now, very anxious to share the draft guidance with you. It will be draft unless and until the Act comes into force, but we would hope to be in a position to share the draft guidance with this committee, and I've spoken to Michelle, and we think that can be done by Friday of this week, so that you have that guidance for debate in the Parliament and for perusal by the committee. Now, the guidance makes it clear, and current breach of the peace makes it clear that everything is really is determined on whether on facts, circumstances and, most importantly, context. But the guidance makes it clear that the offence, that's the offensive behaviour, is not intended to cover, will not cover peaceful preaching or restricting freedom of speech, including the right to criticise or comment on religion or non-religious beliefs, even in harsh or derogatory terms. It's not intended to cover or criminalise jokes or satire about religion or non-religious beliefs. It's not intended to criminalise the singing of national anthems in the absence of any other aggravating behaviour, and it's not intended to criminalise the making of religious gestures while singing national anthems in the absence of any aggravating behaviour. Now, it's very important, and this is what the courts are there to determine. It's very important that the courts have a set of facts and circumstances and the context in which the behaviour took place to determine whether or not something is criminal. That's why we have the courts. I'll give you an extreme example. If you have a bowl of fruit, for example, and you have a banana in the bowl of fruit, and I want to eat the banana, so I unpeel the banana, I eat the banana, and I throw the banana into a bin. That is clearly not criminal. But in the context of a football match, you have the unpeeling of a banana and throwing the banana skin towards a black player who is playing football in a regulated football match. Again, the context in which that occurs would criminalise that behaviour, which in a different context would of course be non-criminal. And that is the point that must be grasped, that we're not intending to prescribe this behaviour or that behaviour. It all depends on the facts, the circumstances and the context. So we'll make the draft guidance available to this committee for parliamentarians for debate next week. And if the Parliament then passes the Act, whenever that may be, we'll finalise the draft guidelines to Chief Constable. So I hope that's of some assistance by way of preliminary remarks.
It's a great deal of assistance, and in particular that we will have this available before we proceed. I believe, by the way, the debate is, I've got to correct myself, the debate is tomorrow morning, just as well I wouldn't have been there. So that's the stage one debate, if that's going through. Alison, I'm sure we'll have lots of questions now following on that. John.
Lord Advocate, you said a citizen needs to know what's criminal and what's not. And I think that's absolutely right. Good law must make it very clear. There are at least 3 areas in the draft bill at the moment that seem to be unclear to me, and that behaviour is sometimes criminal in public places and sometimes not. Surely it's not a good law that you set out by saying, well, you may chant songs or sing songs in another public place, but you may not do it in a football's ground. That's the first one. The second one is the area of disquiet round about the wording round about travelling to and from a match, and it says, even if you're not intending to go to the match. That seems to me very vague. I wonder if you could deal with both of those points.
Well, I'll deal with the first point first. What I would say is just read the terms of the Act, because what it does is it criminalises behaviour at a regulated football match, which is likely to incite public disorder. Now, behaviour is then defined as behaviour expressing hatred or stirring up hatred against a person or persons based on their membership of a religious group, a social or cultural group with perceived religious affiliation, or a group defined by colour, race, nationality, ethnicity, sexual orientation and disability. Also behaviour that's threatening and behaviour that a reasonable person would be likely to consider offensive. Now, I think that I would be reasonably comfortable that that legislation would survive a challenge under the European Convention of Human Rights, that it was inspecific, it was not sufficiently defined. I should also add that, going back to the point, again I hope this is helpful to this committee, is that I think 4 years ago, again I don't wish to name the name of the case, but there was a prosecution in Edinburgh Sheriff Court for making or chanting homophobic remarks at a football player in an Edinburgh derby, and a prosecution was raised on a charge of breach of the peace. And the decision of the sheriff, which we all respect, is that that didn't amount to a breach of the peace. Now, the new legislation, again, it's a point I've certainly not read in any comment in the media about it, is that this would be covered by these provisions, because expressing hatred or stirring up hatred against a person or persons based on membership of a group defined by sexual orientation. So that's another point which I hope to make. I think you had a second point in relation to travelling. Yeah, well, I mean, the definition in the Act is taken from the football banning order legislation, which is currently in place, travelling to and from a football match or watching a match being televised. Now, I'll give you examples of that.
Sorry to interrupt, but you're saying or intending to watch a match being televised. I think so I'm presuming you're talking about people travelling, going to watch it in a pub or in a public area on a big screen. Is that correct? Is that what football banning orders do just now? Yeah,
well, if you look at clause 2, yeah, football banning orders cover that. Just a definition of a regulated football match covers that just now. Clause 2 applies to behaviour at a regulated football match whilst a person is entering or leaving or trying to enter or leave a stadium or on a journey to and from a regulated football match, and also any place other than domestic premises at which such a match is televised. Now, you may say, well, why do you need that legislation? Well, what, for example, if you have a situation where a match has been televised in a pub and disorder breaks out, and type of behaviour that is covered because people are, say, delivering sectarian abuse at a former player for the Old Firm, for example. And this is why the legislation goes beyond a regulated football match and